This is The Law Matters. Of course it does. Hi, I'm Debra Morais, your host and moderator. As we tell you, this long-running program continues to provide legal information, relevant examples, and practical assistance to help you with the law matters, because the law matters. A better understanding of the law puts you in a better position to decide how to help yourself, your family, and your business. As we present various topics, at times we know you may want to decide to, or may decide to, cover the issues yourself. If you do decide to seek outside professional counsel, you'll be better prepared, and as a result, so will the legal counsel that you select. As always, our goal is to help save you time, money, and to achieve the best possible results. And as always, we want to welcome again and thank Attorney David Bazar from the Bazar and Associates Law Firm in East Providence, who continues to weigh in on the legal issues we tackle and provide some interesting and sometimes funny anecdotes. So today, we're going to talk about trusts, specifically the special needs trusts. Supplemental needs, special needs, how is that different from grantors' trusts? What's a Medicaid trust? Who needs one of these things and why? What's taxable? Some of them are taxable entities, some are not. There's a thing called an ABLE account that may sometimes be included to help someone. As we dive into this, we'll explore what happens, for example, if a parent has a child with a disability, it becomes crucial for them to handle the assets so that they pass correctly to ensure that they do not cause that child to lose their special needs government benefits. Incomes and assets matter here. We'll find out more about how that works. So let's do a little bit of a recap, talk about the different types of trusts and some of the terms. And so we're going to focus on special needs, but I think we've talked before about basic trusts, grantors' trusts. Can you explain some of the terms?
So trusts are an instrument that can be used to accomplish many different things, and there are therefore many different types of trusts that can be utilized. So if you're doing a basic estate plan and the concern is avoiding probate, having an easy transition of your assets to the next generation, protecting the assets for the next generation, getting the best possible estate tax result, so many people will use a grantor trust, which is also called a set laws trust, or a revocable living trust. And all of those terms are relating to a trust that the person who is going to be usually the initial trustee and the beneficiary of sets up as the trust maker. And they are able to then put assets into the trust so that if they die, the assets aren't in their name alone. And the trust terms will dictate what happens with the assets that they put in the trust. That's one type of trust.
The grantor is the one who owns the trust?
The grantor is the one who creates the trust. Or the trust maker.
Trust maker. And the beneficiary, might that also be the grantor or the
Yeah, oftentimes the beneficiary initially is the grantor. And again, they've designed this trust usually or sometimes with a spouse, so it can either be an individual trust where each spouse has a mirror image separate trust, or they could do it together as a joint trust. And so the idea of those trusts are we're setting it up to be able to fund other trusts that will flow from that on our death, so we avoid probate. So you put your assets into the trust if you have a spouse and you die. Your assets go from the revocable grantor trust to an administrative trust with a separate tax ID number at that point. The grantor trust generally will use the Social Security number of the trust maker or trust makers. The administrative trust, which is, I'd compare it a little bit to like an estate in probate, when a will is probated and you now gather all the assets to put into the estate. The trust creates its own estate, so to speak, or administrative trust. And you use that to pay the debts of the trust maker or the person who died. You use it to gather up all of the assets to have them in one place so that they can then be distributed out in accordance with the trust. So if there's a spouse who survives, generally, to get your best tax result, the trust will create two separate trusts that flow from that, which are the family trust, which is funded up to the maximum exemption for taxes in Rhode Island, 1.7 or so million dollars. Massachusetts, about $1 million. Federally, I don't have a lot of clients who have to worry about that, but both husband and wife are around $13 million, and it's portable, meaning that you can use your spouses if they haven't used it. So you fund that family trust to the maximum extent that you can, and the rest goes into, if it's a joint trust, the survivor's trust, and now the assets are held in these two trusts, and on the second death, oftentimes we'll take the money from both of those trusts, get a new exemption for the surviving spouse, in Rhode Island again about 1.7 million. I think Mass is $1 million unless the governor changes that at some point, which I heard that might happen. In any event, it then usually will have it go down to what we call lifetime discretionary trusts for the children. So their inheritance is protected in an irrevocable trust of which they could be a co-trustee, but they would also pick an independent trustee. And what happens when you do that is the co-trustee beneficiary can take out all the income that they need, money, principal, for health, education, maintenance, and support. But if they got sued by somebody that they either injured or had a contract with or some other creditor, or they had a bad marriage and were getting divorced, generally speaking, those assets are protected because the independent trustee is the only one who can take out money for those purposes, and the independent trustee is not going to be part of a lawsuit where you hit a school bus or went through a red light and hurt somebody.
Okay, so now with that set up, with children, which is one of the reasons you might have wills and trusts and so forth, what is a special needs trust and how is that used? How does that work?
Okay, there are many different types of irrevocable trusts. And when we're getting into the level of a special needs trust, generally speaking, you're setting up an irrevocable trust that the beneficiary of is usually, not usually, could be a child, or you could even be setting it up for the beneficiary from some other source of income. But it's set up so that whatever money goes into the trust, the specific rules of the trust say that the money can only be used to supplement, that's why it's also supplemental needs sometimes, the needs of the beneficiary that aren't otherwise provided by government benefits. So it's designed so it doesn't interfere with that person's ability to get Medicaid or other types of benefits, food stamps,
SSI,
SSI,
SSDI.
Yep.
And with Medicaid or even SSI and SSDI, it's meant to help people who have a low asset. Makes sense. How does this trust work to make sure that they aren't then penalized or having some funds subtracted?
Right.
How does that work?
So it works based on the terms of the trust. And in the terms of the trust, the beneficiary, the person with the special needs and therefore the governmental benefits, has no control over the assets in the trust. Only the trustee, who is independent of that beneficiary, has control. And the ability of the trustee to use either the income or principal in that trust is limited to the extent that it can't be used to benefit the beneficiary in such a way that it would take away from their other rights and benefits. So, for example, well, to answer the first question, as you said, assets are countable against your ability to get benefits. This is not a countable asset because it's not the beneficiary's asset. The beneficiary only gets money out of the trust as the trustee directs.
And so if their housing is currently paid for, if they have some medical coverage, then that trust can't cover that, but it might cover things outside that. I don't know, is it special therapy, a different kind of medical coverage, a different kind of specialist doctor, whatever they might need, other equipment? It's meant for those kinds of things as opposed to the things that the basic government provided needs and equipment or whatever are. Is that the way that works?
That's right. So most government benefits won't provide, for example, a handicap van. So let's suppose that one of the needs is they need a handicap van to be able to get around. The Special Needs Trust perhaps would be available to pay for that. It can pay for a number of other things too. For example, it can pay for travel. If the person's able to travel but wouldn't have the ability to travel otherwise, a Special Needs Trust can pay for something of that nature. If you have other needs that aren't covered by a governmental benefit, as you said or suggested, a medical procedure that is not covered and you can't get covered but you think is necessary, perhaps the Special Needs Trust could cover something of that nature too.
Okay, and explain the difference between how these may be funded, these meaning the special needs or supplemental trusts. There's a first party, there's a third party. Who are they and how does that work and what difference does it make?
Yeah, so it makes a difference. And the way it works that makes it different is if you're funding it, for example, let's say the person who's the beneficiary is the person whose money is going into this trust from the settlement of a personal injury case, for example. Since it would have been their money and it's going in, that supplemental or special needs trust has to be written in such a way that the state will approve it. So you have to send that trust to the state, the Medicaid division, to review it so that they can see if there's money left over, that perhaps it goes back to the state. So that there's certain rules that go into those types of trusts that are settled first party, I guess you would call that, with the beneficiaries' money that they would have otherwise been entitled to, as opposed to a parent who has a child. It's the parent's money, not the child's money, third-party settlement of it. Those don't have to be approved by the state because you're allowed to leave it to your child. And in the trust itself, you can write in, if something happens to my child who I'm leaving this money to, dies before my other children, then when they die, I want the money to be distributed to my other descendants.
And if the beneficiary has passed, does the trust usually exist to then flow to perhaps other siblings or someone else? Again, if it's irrevocable, it's not that the parents can directly change that, but they would have set that up in advance so that there's a second or a third in line once the primary beneficiary no longer needs it?
Right. When the parent sets up that trust, they will have definitely put in language as to what happens on the death of the special needs child. Usually, as you said, it could go to siblings, it could go to other descendants, it could go to charity. You have the right to set that up when you set up the trust.
So a question comes up when you mention something's irrevocable. You set it up with certain intention, namely to take care of this person who right now is ill, perhaps lives with you. But if that person's situation changes and that trust has already been set up to not take care of her or his housing, his food, his medical, that changes. So how does that instrument respond to what has become the changing needs of the beneficiary? It seems that the parent, if they set it up, they were setting it up based on what's presenting. You're a lawyer, you work on these things. How might you set something up to anticipate these kinds of situations?
There's a number of different things you can put into the trust to deal with certain things like that. In any irrevocable trust, for example, you could put a trust protector, name a person. And when the trust protector is named, generally speaking, that's a person who can change certain terms of a trust within limits based on change of circumstances. So that's one way that a trust can be protected. People often ask me about irrevocable trusts in other circumstances beyond just supplemental needs trusts, which is, I created this trust. We created it for a certain purpose, and that purpose no longer exists. What can we do? So there's a few things you can do. If for whatever reason the things that you did initially have changed, but there's still a need for an irrevocable trust in one form or another, as long as the trust is correctly written, which allows for certain things within the trust. you can decant the trust, and sort of like magic. And what it means, it's not like decanting wine into a bottle, although it's a little bit like that. But you take the trust as the way it was written, and you decant it from that trust into another new trust that has the changes within it, and transfer the assets into that trust. So you sort of have magically changed the terms of the trust within the actual trust that you've initially set up, but you're changing the terms within it, because if the trust allows you to transfer assets out, rather than being required to transfer the assets out and then into another trust that gives you those terms, which is another way to collapse a trust, just transfer the assets out, because if the trust has no assets, then it collapses on its own. But when we decant the trust, the assets stay within that trust, but we found a way, because we could have transferred them out, to change the terms of the trust. And you can't change everything, but there's a lot of leeway in things that you can do. And the reason we'll decant a trust sometimes rather than just deed it out or transfer the assets out is because of the 5-year look-back period, because many times we'll have set up an irrevocable trust for protection against if someone has to go into a nursing home, has Medicaid, that 5-year look-back period that you're concerned about.
Does the 5-year look-back period, does it count whether it's first-party funded or third-party funded, or does it not matter?
Well, it doesn't. That's an interesting question, because if you're gifting the money out, first-party funded to yourself, or to somebody else.
It doesn't matter whether it's first or...
It doesn't. What it matters is the person who's applying for Medicaid. If they gave an asset away, whether to themselves, because they could be an income beneficiary of a trust or whatever, or to their children, which is usually what happens. If you gave the asset away and put it beyond your control, that's where the 5-year look-back period comes in, because it's a gift.
Makes sense. Okay. And then explain what an income-only trust is relative to those who are planning for Medicaid. And I understand that you spend time trying to structure these trusts so that it accounts for the 5-year look-back if you can. So what is an income-only trust, and how does that work to help with the planning?
So a Medicaid Asset Protection Trust can allow for the person who's putting their asset into the trust to be an income beneficiary of the trust. So you talked about this about other benefits, but Medicaid is an asset-based benefit and an income-based benefit. So if you put assets into that trust and you're not allowed to take out the principal after 5 years, those assets you put in don't count against your asset limitation. However, if you're allowed to take out the income will still be countable and available for you to use to pay for your own nursing home if that's the need for Medicaid. So an income-only trust allows you as the beneficiary and the person who put the money in to continue to take income out. So an example of why you might do that is you have rental property. You need the income from that rental property to live on, but you want to protect the asset, so you put it into this trust, and after 5 years, the asset's protected, and the income continues to come out to you, and if you go into a nursing home, the income will still be available to pay for your nursing home.
And what circumstance does it happen that even though there's a trust and a person is covered, say in a nursing home or facilities, they need that kind of support, that after that person passes, that the nursing home would then have access to some of the money that's in the trust to cover expenses for the person's care? So in other words, it seemed that there might be some issue with what's left over in a trust if the person passes away and there's still money left in that trust that was not used. Can the nursing home, and under what circumstances could the nursing home say, well, we did have these other expenses, so we're entitled to that? How does that ever play out?
Yeah, so two things. First of all, generally speaking, it's not the nursing home who hasn't been paid, because they're usually paid by Medicaid.
Yes.
And so there's not usually that situation where the nursing home is looking to come back.
Okay.
The question is Medicaid entitled to come back?
Okay.
Is Medicaid entitled to come back after a person who owns a house and they die? Because you're allowed to own a home when you go into a nursing home.
Afterwards.
It's state specific.
It is.
Yeah,
Good for
even
people
though
to know.
Medicaid is federal money, how it's administered by each state is state specific. California rules actually are much more liberal than Rhode Island. Rhode Island's actually somewhat more liberal than Massachusetts. So in Rhode Island, if I go into a nursing home and I own my home and I need to be in a nursing home, I'm allowed to go in. As long as I intend to return home at some time. I may need that magic pill to be able to get home, but I'm hoping that that happens and I can go back home. So Rhode Island does not require you to sell your home to go into a nursing home. My understanding is that in Massachusetts, if you go into a nursing home, you can have a home, but you need to sell it or go home within a year.
Within a year.
Within a year. And if you don't, then you have to sell it and use the money to pay for your care. Now, that's not the end of the story, because you died, as you said, and what can they go after? Well, in Massachusetts, they have an extended ability to go back after assets that are available or would have been in your estate after you died, or not in your estate because perhaps you did a life estate deed, as opposed to Rhode Island, which only goes after assets that go through probate.
To go through probate. Explain what a testamentary trust is and how that comes into play along this continuum.
Okay, so you can actually create a supplemental needs trust in a will. You can create a trust for children who don't have special needs, but they're too young to have money in a will. So any trust that is created by the probate of a will is called a testamentary trust, because it doesn't exist until the will is probated.
Okay. And an ABLE account. Many people who have special needs, their families are somewhat familiar with them. Some people have one or the other. Some have both. What's an ABLE account and how does that play out?
There's a couple of situations like that. There's the ABLE account. There's also some ability to put money into what's called a pooled account. Or pooled resources. And,
which is?
Well, it's different. It's set up in different states. They have different ways of doing this, but there's an organization or group that has pooled income, and you can put the money into that or into the ABLE account, which is individual. And the money can be used from the ABLE account by the disabled person or special needs person for their benefit. And it doesn't count against any of their other benefits. So that's the benefit of it. However, I believe under the pooled account and the ABLE account, you don't have as much control over what happens to it after you die, after the beneficiary dies.
And the pooled account, was there some distinction about it needing to be controlled by a nonprofit, or just some are? Or
correct. I think in most states that's the requirement.
And are there limits to the amount of money that you can work with under an ABLE account versus when you're doing special needs? What are the limitations?
I think that does differ state to state and by whatever the rules are of that particular state. I would suggest that you probably would be more limited by what you want to give up than what the amount is you can put in.
So when we talk about these things, people can look at that online. What's an ABLE account? How is it funded? What do you do? And some things people can do by themselves. When it comes to the complexities that you are outlining now, would you be saying that this is clearly something that needs to have a lawyer's eyes, maybe an accountant's too, or no?
Perhaps, but here's the thing. The advantages of an ABLE account or a pooled account, pooled resources, is it's simple and you can do it on your own. And you may want to talk to a lawyer about what the rights and responsibilities and the downside is, but you can do that. if you're going to go into the arena of creating a special needs trust or supplemental needs trust one way or another, you definitely need an attorney to do that.
And while we didn't have time to explore this fully, and I wouldn't put you in the place to serve as an accountant, although you certainly know about these things, in many cases there are tax situations that are different from the limits that Medicare, Medicaid has. As I understand it, there are some distinctions between these able and special needs accounts, even if you know that your special needs child has certain interests. You have more flexibility with one account than you do another. One is taxable, one is not. So by the time someone's getting into that kind of situation and you're working with someone, would you automatically find that you'd know at your level as a lawyer, knowing about wills, trusts, enough about what's taxed, or do you need to have an accountant on this?
Yeah,
would you say?
depending on how much you're dealing with, I might be comfortable with it. If we're talking about amount of money that's going to create a lot of income in that issue, I would want to bring an accountant in to just make sure we're taking full advantage of the best possible legal instrument.
Sounds good. We've certainly covered quite a bit of information here about various special needs trusts, and we hope that you found it helpful. We hope you'll continue to stay tuned to The Law Matters. As we say, it matters to you. Thank you for tuning in.